With more lockdowns, business interruption insurance now, as we're just hearing, is a very real issue for the survival of businesses large and small. But like so many insurance policies, this all comes down to the fine print. Now, many insurers simply told their business customers no when they made claims, but test cases have worked their way into the High Court. And on Friday, the Insurance Council of Australia was denied special leave to appeal a decision of the New South Wales Court of Appeal. Now, just to explain, that Court of Appeal judgment took a really hard line on many insurers, essentially telling those insurers that they are beholden to the fine print in their own contracts. The problem is that many of the insurers had failed to update their fine print after the Quarantine Act in Australia was replaced by the Biosecurity Act in 2016. After that, COVID hit, customers made claims, and now they want to be paid. There is really big money at stake here. The Insurance Council estimates there's 250,000 policies and $10 billion in claims here. A House of Representatives Economics Committee is also drilling down into whether insurers should simply pay out customers who have this type of insurance. Tim Wilson is chairman of the Economics Committee, and he joins me now from Canberra.
Thanks for having me, Ross.
This is a pretty tricky situation because, quite clearly, $10 billion is an awful lot of money for the insurance industry to be out of pocket. But by the same token, it's also a lot of money for those people who have taken out this insurance in good faith to be out of pocket themselves.
Well, essentially, the insurance industry is now liable for a lot of products that it didn't believe that it was liable for and hadn't reinsured for. So we're talking in the billions of dollars for businesses that are going to be in a position because of the pandemic last year to claim. So it's one of those weird situations where it's actually the fine print hasn't been properly read by the insurance companies, much less the policy holders, and people now have a justification to go forward and if they haven't already submitted their claims to be able to do so for losses they made as a consequence of business interruptions last year. But we've had insurance companies before us where they're now looking at their own business practices and what they need to do because this is big bickies and it's going to cost them.
OK, so let's just try and explain this to people. Those people who did have insurance with, shall I say, the right company that had made the changes, they might very well not be paid out. But those who are with insurance companies that had not changed their policies, not changed the wording as a result of that change in the legislation, they're the ones that actually might be having to pay out their customers.
That's right. And what has happened in this case is that insurance companies thought once the relevant act was replaced that it would lead to essentially an automatic transmission of business activity, which would go to the new act. And the point that's been highlighted is that doesn't automatically equate just because the Parliament has repealed the relevant legislation doesn't mean that it's automatically replaced by updated law. And so that's where a lot of insurance companies have been caught. And of course, if the insurance company has been nimble and stayed across updates in legislation appropriately, then they might be in a position where they don't have to pay out claims. But if they haven't, and it might simply be because people are using the same policy and they're being renewed, they may have a very legitimate claim to claim for business interruption costs from last year throughout the pandemic. And I've no doubt that insurance companies are racing to make sure, if they haven't already, to make sure that their policies are covering it.
Well, there's a few things here to break down because, say, for example, we all know that there are exclusions in insurance policies, and many of those actually take in big disasters, atomic attacks, very big natural disasters, all these types of things. A pandemic, you would think, would be pretty much straightforward in terms of, something that would be seen to be an exclusion. But it's not just here in Australia. It's in the UK and the US, where they've got similar cases going to their highest courts to try and determine the liability of the insurance companies as compared with the liability of the paying customers of those insurance companies.
That's right, and that's what happens when, quite rightly, I think insurance companies in the past have pointed to legislation and say if it's one of these events is triggered under law, saying like a pandemic, that it will provide general exemptions. But when that doesn't happen, as is the case with the interpretation of these policies, they're left exposed. But more critically, as you said, there's examples overseas where similar situations have now occurred. And of course, I suspect this judgment will have ripple effects, which will raise real alarm in those markets and for those insurance companies about whether the situation can be replicated. But for a lot of small business owners around the country who have made claims, and it may not be a difference between it might in some cases be the difference between making or breaking their business, but critically after last year with some businesses suffering big challenges and cash flow, it will significantly aid their position and at least they'll see real value from their insurance.
Just to give our viewers some sense of this, I mean, IAG, Australia's largest insurer, went into a trading halt when this case was taken to the High Court and then announced it was going to raise some $750 million in new cash from its shareholders to be able to pay out the claims that might potentially come. So that gives people a sense of the scale of the order of what might be sitting inside the pipeline for some of these insurance companies.
And when we've just had IAG before the House Economics Committee where they've specifically addressed that and the fact they're going to have to dip into that capital from following their capital raising because ultimately they were left exposed, as I'm sure other insurance companies will be, because they've now got to honour obligations that they neither sought reinsurance for or not to the full extent required, and ultimately going to have to pay out those claims.
And there's a certain extent in this whereby government is actually a winner also, because if many of these small and medium-sized businesses were going to the wall as a result of, not being paid out this business interruption insurance, they might very well, or even their workers, been back on government handouts and government subsidies to try and make up the difference. So from that point of view, it's a case whereby government effectively is left off the hook as a result of the insurance companies having to make up their own obligations.
Well, I wouldn't say the government's been let off the hook. Government's invested huge amounts of money into keeping small businesses afloat throughout last year, whether it's through the wage subsidy program of JobKeeper or various tax incentives to encourage growth. And we all know that the economy is doing a lot better than most of us predicted 12 months ago or even 6 months ago now. But it does provide for more cash flow for some businesses, particularly to cover that period in the earlier part of last year where there was quite dramatic decisions made almost nationwide, which has now, of course, been replicated in Melbourne and now in Sydney as a consequence of further outbreaks, and will give those small businesses the opportunity they need to be able to get that cash flow to potentially boost their and invest in their future.
Tim Wilson, good to have you on the program. I appreciate your time.
Thanks, Ross.